Hey, everybody. Welcome. I missed you guys last week. I spent a week doing research for a new book. I'm not quite ready to let everybody know what's going on, but I'm super excited about it. And I know you guys are all going to be too. So when I feel comfortable letting you all know what's going on, you all be the first to know. So, hey, we don't have too much to talk about this week, huh? Yeah, we have verdicts in the Vallow case, verdicts in the Reed case, which we are going to talk about at length, and some happenings in Kohberger. So I thought we might start out with the Vallow case. Now, you know, I uh, she just can't help herself, you know? We know that the jury was out, came back in record time. I mean, it was, I think what we heard was they had a verdict in about 20 minutes, and then they sort of thought maybe we ought to not come back quite that quick. And I think they might have waited to have lunch on the court before they before they went forward. I'm going to share my screen because I do want to play this little snip of what went on in the courtroom for Lori. So here we go. Hopefully you can hear that. So what happened was there were objections. They had a sidebar where they wore the headphones, and there was a fairly lengthy conversation, but it's pretty clear that at that point, Lori still just didn't get it. She just wasn't getting what the judge and the prosecutor were laying down. So the judge asked the jury to go out, which is what you can hear in the background is the jury's leaving. And then they're going to have this exchange.
All right, please be seated. The jury is no longer present. We've concluded that sidebar. A record's been made. I would just caution the defendant again. She needs to be very careful, and she's
Sorry about that. I had it on quick speed.
getting into areas that could open a huge door that I don't think she wants open. I'm going to make another record at 10:24 to 10:25. We held a sidebar that I don't think made it onto the court record. That sidebar again discussed similar issues of if the defendant brings in evidence or testimony that she was a good person and no ill intent and those sorts of things, and specific acts of her being a good person, it could open the door to other things that she may not want the door open to. The state, the defendant, and advisory counsel were at the bench when we had that short 1 minute sidebar, but I don't know if anyone wants to supplement the record on that.
So before we go on with this, let me just jump in and say that character evidence, which is what they're talking about, she keeps talking about 403 evidence, and we've talked about this at length because the issues come up in almost every case. So the law precludes you from putting on evidence, precludes the prosecutor from putting on evidence that you have a bad character, for example, or that you've committed a crime. For example, in her trial with Charles, the state was not allowed to bring in the fact that she'd already been convicted in the deaths of Tylee, JJ, and Tammy Daybell. That wasn't allowed because there's always a danger of unfair prejudice. So Jen's putting the information in the chat as we're speaking. So initially what happened was the state filed a motion wanting to bring in some 403 evidence. And as they went along, they withdrew that motion. Between the case for Charles and the case for Brandon, they withdrew the motion. So Lori seemed to think that because they withdrew their motion, they could not object to her trying to get in the fact that she was a nice person and, that she had love for everybody and all of that nonsense. And she just did not understand that the fact that the state said they withdrew their motion asking to bring in 403 evidence was not the same as them not being able to object to her opening the door. So that's the way that the rule works. The prosecution is not allowed to bring in things that would suggest to the jury, that would prejudice the jury, and suggest to the jury that because you did this other thing, you must be guilty of this case. So it's very basic evidence law, but Lori didn't really understand that. And so the judge was cautioning her, please don't go there, because if you start talking about what a nice, peaceful person you are, that opens the door for the state to then just charge right through and let the jury know about all those prior convictions. And now there's 4 of them. So he's trying to explain that to her, and she's not having it.
Okay.
Just, Your Honor, that again, the state did raise any issue of character evidence under 404A and 405, that if the defendant opens the door and tries to advise that she is a good person, a peaceful person, a kind person, a loving person, any of those other types of things, that we believe that would allow us under 405 to then bring in specific acts, such as the murder of her children, her husband, and her current husband's wife.
All right.
Which would also be 404B that they withdrew.
No, it'd be 405.
Yeah, they withdrew it, but if you bring up 404 that you...
Then all 404B is in, or do we get a hearing on what 404B can come in? If I open the door, do I get a hearing? We stop trial
and she is just, we don't know what happened at sidebar, but at this point, she's wound up pretty tight. And she's now talking about, well, do I get a hearing? Well, generally what happens is in this sort of a situation, in the middle of trial, the prosecution would stand up and say, if she opened the door, by saying, I'm a really nice person and I would never hurt anybody, then she opens the door and the judge would say, I need a sidebar, or I need to talk to the parties outside the presence of the jury. The jury would be dismissed and the judge would say to her, ma'am, you've opened the door. Now all of that information comes in. Because the prosecution would promptly stand up and say, we want to bring all that information in. So it's not really a hearing, but there would be on the record conversation about it outside the hearing of the jury. But she's adamant that somehow that she needs a separate 404 hearing if she opens the door.
get a hearing on.
Stop. We'll have a very short hearing, okay? If you're going to introduce how you have great character and good character,
So
again, discuss similar issues of if the defendant brings in evidence or testimony that she was a good person and no ill intent and those sorts of things, and specific acts of her being a good person, it could open the door to other things that she may not want the door open to. The state, the defendant, and advisory counsel were at the bench when we had that short 1 minute sidebar, but I don't know if anyone wants to supplement the record on that. Ms. Kay?
Just, Your Honor, that again, the state did raise any issue of character evidence under 404A and 405, that if the defendant opens the door and tries to advise that she's a good person, a peaceful person, a kind person, a loving person, any of those other types of things, that we believe that would allow us under 405 to then bring in specific acts, such as the murder of her children, her husband, and her current husband's wife.
All right.
Which would also be 404B that they withdrew.
No, it'd be
Yeah, they
404.
withdrew it, but if you bring up 404 that you.
Then all 404B is in, or do we get a hearing on what 404B can come in? If I open the door, do I get a hearing? We stop trial and I get a hearing on.
Stop. We'll have a very short hearing, okay? If you're going to introduce how you have great character and good character, we're going to have a short hearing on what evidence that they can bring in to rebut that character, which could include being convicted of 4 murders. So,
And would you
talk to
like?
your advisory counsel during the break. And
You don't need to yell at me either.
okay?
Yeah, you are, and you do not need to talk to me that way. I'm very curious. I'm very courteous to you.
No, you have been nothing near courteous to me during the course of these proceedings. Talk with your advisory counsel about the rest of your cross. We're going to resume in 15 minutes.
Whew, mercy. Now, I have to say that Judge Beresky has been really, really patient with this chick. He has definitely been patient, and she has tried his patience from time to time. But I think that was just a bridge too far. And it was an interesting exchange between the two of them. He did sort of take a deep breath, and they had a 15-minute break, and he came back a little bit less worked up than he had been. I think he has done a really good job of remaining patient with her through 2 trials. He did a very good job. And I'm sure, as you all know, she was convicted in very short order of conspiracy to murder Brandon Boudreaux. So Brandon's testimony was quite compelling. He was, you know, when all of this began, and when JJ and Tylee's bodies were found, when Brandon Boudreaux found out that the children's bodies had been found in Chad Daybell's yard, he got in his car the day after his remarriage, right within a day or two, got in his car and drove straight through from Arizona to Idaho. That's something like a 17-hour drive. And he drove directly. The very first place he went when he got to town was Kay and Larry Woodcock's hotel room. And he saw them. Larry was in bed. He was very ill, and he was having vertigo, so he couldn't even stand up. And the sheriff had just called and asked for them to come down and positively identify JJ. And Brandon Boudreaux said to them, "Please let me do this." Now, this guy had just driven 17 hours. He was exhausted, but he said, "I can't let you do that. You're not in any condition to go anyway. And I can't let that be your memory of JJ. I can't do it." So Brandon Boudreaux was the guy who went down. Now, remember, this is Lori Vallow's niece's ex, right? I mean, he's part of the Vallow side of the family, and or the Cox side of the family, I should say. And but he's the guy who said, I can't let you do that," and went and performed that service for Kay and Larry. He's always been one of the people who sort of got caught in the crossfire. He's always been one of the good guys in this whole sordid saga. The other thing to know about Brandon is that right out during the time that he was getting divorced from Melanie's lawyers in California sent out news releases to media organizations, informing them of all of these things that Melanie and Lori said were true about Brandon, that he was gay, that he was a criminal, that his family dealt drugs. I mean, the list just goes on of all of the horrible things that they said about him. None of them were true. Brandon sued for defamation, for slander and libel. And he sued both lawyers in the firm. And the lawyers settled. I'm certain that their malpractice carrier said, you're going to settle this, because if you go to trial, there is no defense. You're going to be lucky if you if you still have a shirt on your back. And so they settled for $12 million. Out of all of this, that felt like a little bit of justice for Brandon, because his reputation was ruined, and it was awful. But he appears to have, his life appears to be going in the right direction. He is remarried. As far as I know, the children, his children with Melanie are with him primarily. And Melanie's been kind of quiet. And we heard during Brandon's trial, the prosecutor said, Melanie's not out of the woods. And I know there are a lot of people who would like to see Melanie held accountable for some of the things that she did, particularly the fact that it had to have been Melanie who told Lori and Alex Brandon's new address, because they were the only, Melanie was the only person who knew, other than a couple of his neighbors and work friends who had helped him move. But he explained in court that his move out of the family home and into a rental happened really quickly. And part of it was that Melanie announced that she was going to be going out of town, and she wanted him to take the children, and he needed to move into a place where he could have the kids. So it all happened really quickly. And other than the guys that helped him move, Melanie was the only one who knew the new address. So that's pretty suspect, or sus, as the kids say. So I think that Trina Kay isn't done yet. And she did a very good job on both these cases. Now, she also didn't have a lot of pushback. There were many leading questions, because Lori didn't know how to spot a leading question and how to object. And I think she even got some hearsay in at some point. But that's what happens when you represent yourself and you're not a real lawyer. You just play one on TV. So Lori has been, she has not been sentenced yet. The judge ordered a pre-sentence evaluation, and her sentencing is, she wanted to be sentenced and get the heck out of there ASAP, because the Idaho corrections is much more comfortable than Maricopa County Jail, I guarantee you. So she was asked to have her sentencing right away, and the judge said, no, we'll do it in the ordinary course. He wasn't overly sympathetic to her getting moving. So they will be setting sentencing for both cases. So she will be sentenced on both. She has not yet been sentenced on the death of Charles Vallow. That she opted to have that sentencing after this trial was over. So she'll be sentenced on both cases. Ultimately, she will be transported back to Idaho, because Idaho has dibs on her, and she has a life without parole, 3 life without parole sentences there. The maximum she can be sentenced to for Charles's death, well, actually, I think on both cases, even though because she's been convicted on conspiracy to commit murder in both cases. So in each one of the 2 cases, she could be the maximum she could be sentenced to would be life in prison with the possibility of parole after 25 years. There is not a life without parole sentence available in Arizona for conspiracy to commit murder. So that would be the maximum sentence. So she'll be on her way, and I hope that this is going to be closure for everyone involved. I hope that Kay and Larry can really begin to move on with their lives, and that the rest of the family can find some peace, and not have media and people clamoring at their door all the time. So I hope that for all of them. So we also had a little bit of excitement in the Kohberger case. So I wanted to pop in and talk a little bit about that. So there was a hearing today. Poor Andrea Burkhart was trying to shuffle between Kohberger and the Reed verdict at the same time, but timing-wise, it managed to work out. So there was a hearing today in the Kohberger case. And what was going on was Ann Taylor, Kohberger's lawyer, and her team, have been asking the court to delay the hearing, the trial that's coming up in August. They want more time. So Ann Taylor has made this request. Today was the day that it was argued, but we knew this was coming. She'd sort of telegraphed it at the last hearing. The defense is asking for a continuance for two reasons. They're saying they need more time for investigation, including more time for the mitigation investigation, because remember, this is a death penalty case. And because there has been so much media coverage, and there's more media coverage coming, that they want more time for that media coverage to be diluted in people's memories. She said they have received 68 terabytes of discovery, some as recent as last week. Now, when the prosecution got up, they said, we didn't send you anything. We're not sending you new discovery except for discovery of interviews that we've done with defense witnesses. So they're defense witnesses. You should already know what they're going to say. She's adamant that she has not been able to review everything, and that the fact that they've been meeting their deadlines doesn't mean they're going to be ready. She went heavily down the road of Mr. Kohberger is entitled to effective counsel, and if I'm forced to go to trial in August, he's not going to have effective counsel because I will not have done everything that I need to do to prepare. And she talked at length about the ABA guidelines. The American Bar Association has guidelines that they have created for death penalty cases, and in particular for the mitigation phase in death penalty cases. Those are considered by most state Supreme Courts as best practices in death penalty cases. So the ABA guidelines have been used by been adopted by most state Supreme Courts as the measure of what is reasonable for effective assistance of counsel, and to prove that there's no lack of diligence. The other thing that she pointed out is that the media coverage that's going on, they'd had sort of a lull in some of this media coverage, and all of the sudden exploding onto the scene was a 2-hour Dateline. And she made the point, and I thought that she probably didn't make it strongly enough, but it's not as if that Dateline episode airs and then nobody ever sees it again, like in the good old days, right? Before we had streaming services and the internet. Because now what happens is people can watch that anytime they want on demand. And, somebody can be sort of scrolling through and go, oh, there's a new Kohberger episode. There's a lot more coverage. A lot more people are going to see it over a much longer period of time than would have been the case in the good old network TV days. Because at this point, once it's out there forever. So the other thing that is happening is the author James Patterson, who writes legal thrillers and sort of detective books, is writing a true crime book about the case, and it is due to come out right about the time the trial starts. I don't think that's an accident. And there also is going to be a scripted docuseries that's going to be released shortly after the book is released. So right about the time trial is going to be underway, this book is going to come out. Patterson has a big following, and it's going to get capped off by the book being made into a docuseries. It's going to air right about the time that the book comes out and the trial happens. So I understand her concern that that is going to make it more difficult to seat a jury, but the judge has definitely has said repeatedly it doesn't make it impossible to seat a jury. So the state's position was that that the judge's question had to be, does denying the motion to give them extra time amount to unfairly prejudicing Brian Kohberger? That it can't be a decision based on the possibility that counsel could be found ineffective if there's an appeal. Because the only way you get an ineffective assistance of counsel finding is in the appeal process. That doesn't happen at the trial level. No trial judge is going to say, oh, Mr. Kohberger didn't get a fair trial because his counsel was ineffective. That only happens at the appellate level. So essentially what the state was saying was it's kind of speculative to say, if you don't grant this, it is going to be ineffective assistance of counsel. And the state made the point that if we're going to consider a continuance each time something hits the media, we're going to run the risk of perpetual continuances because the case is going to continue to be in the media. And and I wanted to make the point that courts have said a defendant is entitled to a fair trial. A defendant is not entitled to a perfect trial. Now, we as defense attorneys want to give our clients a perfect trial. We want it to be perfect, but we all know that that's probably not realistic, even if there are unlimited resources. So, and we saw in the Karen Reed trial, that in spite of the fact that she had this amazing team and they really did put on an excellent case, they still got a hung jury. So we're going to talk about Reed in a minute, but I want to get through Kohberger first. So this judge has been very, since they moved the case from Moscow to Boise, and it's in Ada County, same courthouse where Lori Vallow and Chad Daybell were tried. Now, what the state of Idaho says is if you get a change of venue, the judge on the case can either stay with the case, which is what Judge Boyce did, and he moved with the case to Ada County, or that judge can say no thanks, and they appoint a new judge, and that's what happened in Kohberger. Judge said no thanks, I don't want to try a case in Boise, and they appointed Judge, I think is Hillier is his name, and he has been very no nonsense from the beginning, very straightforward, very hesitant to seal documents, very hesitant to keep things out of the public. Now, they did have a sealed session this afternoon, and I'm not entirely sure what that related to. It may have had to do with medical records. It may also have had to do with Hippler. There's been a couple, thank you, Tiff. There's been a couple of cases that have had judges with similar names, and this one I just can't get that one to stick. So thank you. He's been very straightforward, no nonsense, keeping things on track, setting hearings right away. I mean, he's definitely been trying to move things along. So he said he was going to take the motion under advisement. He was going to issue a written decision, but he also said, I think you should presume that we are going forward as scheduled, because the trial likely will go forward. And he used the word likely. The trial will likely go forward as scheduled in August. So I think we're going to have a busy summer, because that trial is going to start, and they have actually set aside until November to try that case. And there are quite a few other things coming up too. I didn't go through my list and double check dates, so I'll do that for everybody next week. So now I want to talk about Karen Reed. First of all, I have to play for you this really sweet and amazing footage. There is a YouTube creator called Microdots, and they have been involved. They use a lot of AI technology, and they actually were involved in cleaning up and sharpening some of the video that was used in the trial, particularly the video from the Waterfall Bar and Grill. But they have been, from the beginning, have been huge supporters of Karen Reed. So let me play this, because this came out today, and it's amazing. It's amazing they could put it together this quickly, but here goes.
reed was pointed in this direction and it sounds on Fairview Road, and they want us to believe.
They were perfectly content when the Norfolk DA's office, the Massachusetts State Police, and the Albert family controlled the narrative, each vouching for the others, reinforcing their shared version of events. Then something miraculous happened. With only her close friends and family by her side, she had the bravery to stand up to the machine, climbing back from hell, out from the grave they had dug for her. And with the help of a fearless journalist, inspired the multitudes to stand with her.
Please subscribe to Microdots. I just dropped the link in the chat, and they have done some amazing work on this case, and they definitely deserve a subscribe. So please do that. And thank you, Microdots. I think that they are happy to have it shared far and wide because they've been big supporters from the very beginning of Care and Read. I think one of the most interesting, let's talk a little bit about the jury verdict, because then I want to talk about how Care and Read, this case is going to change I think the way we cover cases, and I also think it's already changed a lot. So earlier today, we got this weird, now there were some odd dynamics going on. Yesterday, there was a jury question, 3 jury questions, and they, as expected, they had questions about the verdict form, and they had questions about a particular issue. So before the trial, before the jury instructions were given, the defense opted to include as a lesser included offense. The second count was vehicular manslaughter while under the influence of alcohol, essentially. And they opted, after quite a bit of consideration, to include in that count a standalone operating a motor vehicle. In there, they call it an OUI, operating under intoxication, I think. A lot of states call it a DWI or a DUI. So it's drunk driving, basically. So they opted to include that. And I think they did it because they felt that what they knew from juror interviews from the first trial was that the jury was hung up on the issue that she had been drinking and driving. And they wanted to give the jury something that where they could say, okay, she didn't kill John O'Keefe, but she was driving drunk. Now, we don't have to talk about Yuri Buchanan driving in his police cruiser drunk, but that's another story. But I think they felt like it gave the jury an off-ramp if they were hung up. So they sent the jury the verdict form, but the defense expressed concerns about the way the verdict form was written, and actually asked the court to rewrite the jury instruction prior to giving it to the jury. And of course, the judge said the instruction's fine. Well, then when they got the jury question, the judge then had to back down and give the jury a revised verdict form which had been what the verdict form the defense had suggested all along. Even at that, it took a while. But after they got this instruction, because they asked, their question was, if we find her guilty on the DUI, does that mean we're finding her guilty on all of the more serious charges? Can we only find her guilty on the OUI, on the drunk driving charge? Or do we have to find her guilty on the manslaughter causing death while intoxicated? And the judge didn't give the greatest answer, but the jury seems to have figured it out, because the other thing that was really weird was they came back this morning, everybody, they went into deliberation, and then the call went out that the verdict was in, and they called everybody back. So everybody waited and everybody rushed to the courthouse. And then they said, oh, wait a minute, not so fast. So apparently what happened was they signed and completed the verdict forms, passed them off to the court clerk, and then at some point knocked on the door and said, wait a minute, we're not there yet. And the judge then sealed those verdict forms, and they were given new verdict forms. And then very shortly afterwards, the word came that the verdict was in. And but it took a while for them. I mean, there was reports that Karen Reed and her team were in the courtroom, and Alan Jackson was pacing, and it took a while before the judge finally came out on the bench and took the verdict. It wasn't really clear why that happened, whether that had to do with, some people thought that perhaps they were trying to secure the streets around the courthouse because they shut the streets down and they had helicopters, and it was, you saw on the microdots video, it was really an overwhelming turnout. So the judge came in, took the bench, they took the verdict forms, the clerk Jim read them, and in Massachusetts, what they do is they ask the jury foreman as to count one, what's your verdict? Count two, what's your verdict? So the foreman said not guilty on one, and then on count two, guilty only of the lesser included of DUI, and then count three, not guilty. I mean, when the first not guilty came out, the crowd just roared out on the street. It was like you could hardly hear anything going on in the courtroom. They were so loud. Even though they had been directed repeatedly, when the verdict comes in, don't do that. But the outcry was huge. So then there was quite a while. Karen Reed, so they asked when the judge asked, when do you want sentencing? And Brennan, to his minor credit, said, let's go forward with sentencing right now. And so they sentenced her to a year of probation for the drunk driving case, which is typical of a first offense drunk driving in that area. And the judge said, do you want the sentence that everybody else gets, basically? And she said that. You're recommending the first offender same sentence everybody else gets. Yes. So they then finished that. There were a couple of other admonitions she had to be given about whether or not the documents would be sealed because of the not guilty verdicts. And then it took quite a while for them to come out of the courthouse. Someone suggested that she had to go directly over to probation, which is in the same building, and do the paperwork to get signed up on probation before she could leave the courthouse. So she came out onto the courthouse steps. She made a very brief statement, said, I think just 2 sentences. No one has fought harder for justice for John O'Keefe than me. And I'm deeply grateful to my team and to all of the people who have supported me and my family. And that was it. And they shuffled her into the back of a car and off she went. So there were lots of hugs and tears in the courtroom afterwards, and it was very moving. And I think there's going to be some pretty serious fallout to it as time goes on. So one of the things that I wanted to talk about, though, was how this case unfolded and the role that social media played. And we're seeing this more and more in cases. We're seeing more and more. Typically what happens is the prosecutor is the one who gets to who gets to set the stage and to tell the story ahead of trial. The prosecutor is the one who presents the case to the grand jury. The prosecutor is the one who writes the indictment and decides what to include and what not to include in an indictment. It's the prosecutor who really has the forum, the bully pulpit to talk about being tough on crime and all of those things. And we're seeing a huge flip in that with the rise of social media, and particularly of YouTube content creators, and especially LawTube. People like Andrea Burkhart and like Bob and Ali Mata from Defense Diaries, and like Melanie Little. And we're seeing people turn to lawyer creators because they want the truth and they want to understand the process and they want to hear, what does that mean? So I think we're hearing much more of that. But I think the Karen Read case was a real watershed. You saw the crowds that were out there. Now, this was a case, and I have not ever been a huge fan of Aidan Kearney, who's goes by Turtle Boy. But I will say that that this case would not have gotten the attention it did if it hadn't been for him. He lives in Massachusetts. He was a local, and he felt from the very beginning that Karen Read had been unjustly prosecuted, and that the system in the Boston area and in Massachusetts in general, and in the Massachusetts State Police was corrupt. And he was right. He was the guy who was making a lot of noise over the fact that he felt she had been unjustly prosecuted and that they were doing their best to pin it on the girl. So, had it not been for him, I think this case would not have gotten the attention that it did. In addition, he he has a very out there, bombastic, shock jock kind of style, and a lot of people love him. He's not my cup of tea, but I think what he did turned out to have been really amazing. And he put his own liberty on the line to do it. Um, so he came out and said, I don't believe she's guilty. I believe these cops are corrupt. I believe that they're dirty. And he turned out to be right. We've seen that. We've seen the firing of Michael Proctor. We've seen Lieutenant Tully being demoted. We've seen quite a few law enforcement officers suffer some consequences, and I have no doubt that that is soundly because Aidan Carney put it on everyone's radar. At one point, he was being quite bombastic, and he was getting in the face of some of the witnesses, and he was accused of witness tampering. Now, that case is still pending, but it'll be interesting to see how that case gets resolved now that Karen's case is adjudicated. So, I think we're going to see the dismissal of some of the cases. They've already dismissed some of the counts against Aidan Carney, and I think we're probably going to see dismissal on some of the other ones as well. So, but what happened was this huge groundswell. It was interesting today. Court TV, Vinnie Politan was out there, and he was talking about this is something you never see. This huge crowd out there supporting a defendant in a case about the death of a Boston cop. I mean, someone accused of causing the death of a police officer. That's unheard of, that you would have that level of support for someone. So, and he's right. It is kind of unheard of that you would have that level of support for someone who is accused of murdering a police officer. But I think it goes to show the reach of social media and the importance in some ways. It really is a return to a grassroots sort of democracy, that people are holding government to account in the ways that we're meant to. I find that very exciting, the idea that, this groundswell of, we're going to hold government to their responsibilities, and we're going to hold government to test. We're not going to allow them to have unlimited power and unlimited resources. And I think that it's really troubling that the state of Massachusetts has spent millions of dollars prosecuting Karen Read to get a DUI, a misdemeanor DUI. So I think that the public's really got to think twice about their elected officials. And I think the public has got to think twice about the way that we put judges into office. Because in Massachusetts, they are political appointees. The same in South Carolina. We saw that in Murdoch. And I think that it's dangerous when judges are political appointees and are beholden to the powers within the state. I think that's dangerous because there isn't a safety valve. There isn't a way for the public to say, wait a minute, this judge isn't doing the people's work. And when she comes up for reelection, we want to be heard. That's not possible in Massachusetts. And I think that's unfortunate. So, uh, but I think that we are seeing social media in general, and I'll point out it within my local community here in Oregon, we had a very heavily contested sheriff's race, and we had the sitting sheriff, and we had a challenger. And it came out that the sitting sheriff had been retaliating against the challenger, who was an employee of his. He was a deputy within the sheriff's department. And so the sheriff was using his position to retaliate against this person for challenging him in an election. And the public didn't like that. And it came out shortly before the election. And as a result, the challenger won. Now it's come to the attention within 6 months of the elected district attorney, who is a guy who I absolutely admire. He's just the salt of the earth, best the best face of prosecution. I mean, he's just a straight up great guy. And I've known him for 25 years. So when he announced on social media, so this is the social media link, that he was placing the newly elected sheriff on what's called the Brady list, that created a problem. So every jurisdiction has a list, came out of a court case, has a list that they make public of police officers generally, but any government official who they believe has been dishonest either in their government capacity or has been dishonest when they have testified in court. Hopefully that was clear. So the district attorney maintains that list. And it's important for people to know that they're public officials, if their public officials are being dishonest, either in the way that they're carrying out their government duties, or in their in their lack of candor to the tribunal. And it's important that people know that. And our district attorney publicly put our elected sheriff on that list, not only for having been dishonest, a la Shannon Burgess, about his qualifications and his education, but also because he'd been caught in lies before the courts. And so he is dragging his heels, but is on his way out as our elected sheriff. And I think that we are seeing more and more of that as the public is becoming, this information is becoming more widely dispersed and in a real grassroots, believable sort of way. Now, we all know that you can't trust everything that you read on the internet or hear on YouTube. We all know that. But I think that making information accessible to people and asking them to apply their common sense and to apply their critical thinking to it, I think is a good thing. And I think we saw that today in the Reed case. We saw that huge crowd turn out in support of Karen Reed because they knew that the government officials who had brought this case against her for so long were corrupt and were dishonest. So, I think we're going to see more of that. I think we are going to see much more of these high-profile cases. I expect that Kohberger is going to be a very high-profile case. The law enforcement agency that investigated the case was in a small town, and I think you run into the same sorts of problems that we ran into in Rexburg, and we ran into in Delphi, and you get these small rural police agencies that are not really well equipped to deal with high profile heinous crimes, and police investigations get bungled, whether it's Canton Police Department or Delphi or Rexburg or all of them. And I, I I think those are things that it's important for the public to know for a number of reasons. It's important for the public to know when your sheriff comes up for election, or if where the bond measure comes up and the sheriff is asking for more money for equipment and training. It's important for people to know, well, gosh, is my community going to be equipped to deal with a case that's going to become worldwide news? Is my police agency going to be equipped to deal with a horrible violent crime? Do they have the resources? Do they have the training that they need in order to make sure that justice is served? So I think those are going to be questions that a lot of people um, are going to be asking. And I mean, I think the Karen Reed case really illustrates that. Um, I don't know how much was spent on the first trial, but it had to be several $1,000,000. We know that Hank Brennan probably is going to make $1,000,000 in fees by the time the case is over. We know that they paid the accident reconstruction people almost $500,000 to paint blue paint on their elbows. So we know that the Commonwealth has pumped many millions of dollars into this case, and what did they get from it? A DUI, a misdemeanor DUI. So I think that we are definitely going to be seeing a lot more of this, and I think we're going to see some real shifts in the way that cases are being prosecuted. I hope that we're going to see some shifts in the way that cases are being prosecuted. Because I think Karen Reed definitely has made the public think, what is this all about? When, uh, how far do we allow our elected and appointed officials to go when they're spending our money? So it's been a really fascinating several weeks watching the trial. Karen Reed is, to my understanding, is about $5 million in debt. Her attorneys have been working for free for some time, and she has lost everything. She has lost her home, her retirement, her job. She really is literally starting over. So it will be interesting to see what she decides to do with this experience. I know that there is a civil case that has been filed. The family of John O'Keefe filed a civil case against Karen Reed for wrongful death. Now, if you remember back to the OJ trial, OJ was acquitted, but the family then filed for wrongful death and he was found liable in the civil case. And here's the reason that happens. So double jeopardy only attaches to the criminal portion, Okay. So Karen Reed cannot be retried for John O'Keefe's death in any way. However, the civil case, double jeopardy doesn't apply. Here's the reason. Because a civil case has a different level of proof. So in our system, we have 3 different levels of proof. The first one, beyond a reasonable doubt, is in all criminal cases. And that is, different people say different things, but, you have to say, I'm 98% sure that the evidence supports a conviction. Then we have this intermediary called clear and convincing evidence. And it happens, it's used in a few places in the law, often in restraining orders and restraining order violations and those sort of things, where you don't require quite as much evidence as beyond a reasonable doubt. And we usually say clear and convincing is like 75% if you gave it percentages. And then you have by a preponderance of the evidence, which is the civil standard for any civil case, whether it's a slip and fall or a car accident or a contract dispute. Any civil case is decided by a preponderance of the evidence, and that is 51%. So in a wrongful death case, the standard is a preponderance of the evidence, has to tip the scale just a little bit more likely than not. So because there's a different standard, you can get a different result. Now, all of the sworn testimony from both of Karen Reed's trials can be introduced as evidence within the civil case. So all of the information that came in from the ARCA witnesses, from the people who said John O'Keefe wasn't hit by a car, all of that evidence comes in. So it may be difficult with a complete exoneration in the criminal case to then get a civil judgment. I think the difference in the OJ case was there was always that doubt about whether OJ actually committed the crime of murder. In this case, because the mechanism of John's death is, they claim, being hit by a car, all of that evidence about that John O'Keefe wasn't hit by a car comes in. So I'm not sure they have the strongest wrongful death case. Now, the other question is, can Karen sue the Commonwealth? And I do think that there is a question about, because she was convicted of something, whether or not she can bring a case for wrongful prosecution. But I think that because of the fact that what she was convicted of was completely disconnected and divorced from John O'Keefe's death. All they said was you were operating a motor vehicle while your blood alcohol was over 0.08. There is absolutely no connection to John O'Keefe's death in that conviction. So I think she still can bring a suit against the Commonwealth. And and as well as I think that she will sue Michael Proctor, both in his capacity as an officer and personally. And so there are protections, lawsuits against suing cities and towns and government entities. There are protections against that, but they do not protect someone from intentional acts. And it's very clear from the findings from Michael Proctor's termination that those were intentional acts. So he's not protected from that, and nor is the city. protected from the intentional acts of one of their employees. So I think we're going to hear much more about those suits, those civil suits, as time goes along. And I think that Karen Reed does have a cause of action against the city and the state, and some of those people individually. And I do think that that her exoneration is going to help her in the civil wrongful death suit that the O'Keeffes have brought. Yeah, I definitely think that they're going to be rethinking that. So with that, I think we're ready for some questions. So while Jen is pulling up questions, I want to remind everybody, please hit the like button. Please subscribe if you haven't. I have got some very exciting things coming up. I think by the end of the summer, we're going to see some big things happening in Chasing Justice world. So please, if you have not subscribed, please do. And please let's hit the like button because it does help the algorithm. And we've been kind of flat when it comes to new subscribers and kind of flat when it comes to likes. So please. What you got for me, Jen? Hi, Russ. Will all Lori's bad acts be admissible at her sentencing? That could be interesting if she decides to produce a version of her Idaho speech. Yes, prior convictions come in at sentencing. So your criminal history comes in at sentencing. Now, is the judge going to get deeply into the facts of the earlier cases? Likely not. But it is a consideration at sentencing. She will be permitted an gosh, my lips are not working. Allocution. Thank you. She will be permitted an allocution during her trial or during her sentencing. Sorry, and I fully expect that she's going to give some version of her Idaho speech that she wasn't involved in any of the deaths and that she's not responsible and that it was all Tylee and JJ and it was all Tylee and Alex's fault and Tammy Daybell overdosed and yeah, we'll hear all that same old song again. But remember, this judge is going to be presiding over that, and I don't think he's going to be moved at all by anything Lori Vallow has to say at this point. So, good question. Hi, Eat the Food, Tina. I believe that Lori and Chad can write letters to one another. After Lori's trial, the judge removed the gag order between the two of them, the no contact order. And so I believe they can. I think they probably can have phone contact as well. But remember that everything they say and do is recorded. So all their jail calls are recorded. All of their letters are reviewed and recorded. And we know well that the prosecutors and law enforcement, both in Idaho and here, are well aware of their silly little coded messages, whether Chad's talking about Ray, meaning he's talking about Alex Cox, or whether they're talking about everyone being happy in heaven. There were all sorts of weird little coded messages that they were passing to one another. So law enforcement is well aware of that. And I mean, they're well aware that in general, inmates code their letters. So that's no surprise to them. And they're pretty savvy to it. So I don't know that it's going to do either one of them much good. She still persists in wearing a hair tie around her wedding ring finger, and still persists in calling Chad her husband, and we don't have any indication on the other side what Chad is thinking, whether he's still all in on Lori or not. We don't really have any indication one way or the other. So that remains to be seen. At this point, Chad Daybell has not given any interviews. He has not given has not really made any statements at all. Hi, Rachel. I wonder what's next in line for Chad. Well, he's anytime you are convicted and sentenced to death, it is an automatic appeal to the Idaho Supreme Court in this case. And so he is simply waiting for that process to play out. So he has court-appointed appellate lawyers. And as we saw with Lori's case, it took a very long time to get the trial transcript done. It can take months. As far as I know, the Delphi transcript hasn't been finished yet, and he was convicted in November. So it takes months sometimes to get those written transcripts for these really long trials. So I'm sure by now they have a transcript and they are moving forward with the appellate process. So his lawyers will file an appeal. The state will have 30 days to answer, and then the Idaho Supreme Court will decide whether or not to hold a hearing. The state Supreme Courts don't hear every appeal that comes before them with oral arguments. There are some that they decide on the filings. Now, I don't know in Idaho whether all death penalty cases get a hearing or not. I don't know. I haven't dug into it that far. But that is probably maybe late this year. If the opening brief has been filed, it might be late this year before they make a decision. And then he will continue to try and have his death penalty conviction overturned. That means that he will likely file an action to habeas action, and then will go up to the U.S. Supreme Court. So he's got a long road ahead of him. Idaho doesn't execute people. I mean, the people who are on death row now have been on there 30 years. The Idaho legislature recently, within the last 2 years, reinstated the firing squad as a method of execution. One of the things that was standing in the way was their inability to get the drugs that they use for lethal injection. Most of the companies that create those have declined to sell them to states for lethal injection. So the states have had to go to what are called compounding pharmacies. They've gone to pharmacies that are able to make the drugs out of their precursor and component parts. And so there's that. There are a couple of states who have explored the carbon dioxide chamber, and which is horrendous. And Idaho has reinstated the firing squad. Now, Chad Daybell was convicted before that the firing squad law went back into effect. So he is not eligible for the firing squad. However, Brian Kohberger would be, because his charges haven't been, his conviction has not happened yet, and the law is now in effect. So Chad is not eligible to be executed by the firing squad. His execution would still have to happen by lethal injection. So, and who knows? Like I say, there are people who've been on Idaho's death row for 30 years. So I don't think that he's going to be executed anytime soon. And he may very well die in prison before that happens. Hi, Beth. Can Lori's sentences be concurrent? Would that equate to 50 to life? Okay, good question. Because they are separate cases, they're not multiple counts in the same case, they cannot be concurrent, as far as I know. Now, every state's sentencing matrix and sentencing rules are a little bit different. So I say, as a general rule, because they are two completely separate cases and not individual counts within a case, they would not be able to run them concurrent. Well, they wouldn't be able to run them consecutive, let me put it that way. The judge could very well say you have to serve your sentence on Charles before your sentence on Brandon. The judge could do that because they are two separate cases. I don't know that. I think she's going to get life with potential for parole after 25 years. That really is sort of a belt and suspenders. Now, it was absolutely necessary that these cases go to trial and that she be convicted for them, because Brandon and Charles were entitled to justice, and their families were entitled to justice, to hold Lori account for her role in those crimes. From a completely realistic standpoint, she has 3 life sentences without the possibility of parole in Idaho. So really the only way she would ever serve these Arizona sentences would be if for some reason, the Idaho convictions were overturned. I think that's unlikely. So I think it's very unlikely that she's ever really going to serve those Arizona terms. But I think that it was important for many reasons for them to be pursued, not the least of which was that Brandon and Charles were owed justice, and she needed to be held in account for that. But also that oh, thanks, Beth. Also that it's sort of like a backstop just in case the Idaho case charges were to be overturned, the convictions were to be overturned. So the judge can run the 2 sentences in Arizona. He can say, you have to serve this sentence before you serve that one. So he could do it consecutive. But the judge, I don't believe, could run the sentences concurrent because they were 2 separate charges. Like I say, Arizona law might be different. And I haven't delved deeply enough into their sentencing guidelines to give you a definitive answer, but my off the top of my head answer is the judge could make them consecutive, but probably could not make them concurrent, I think. So is it Alder knows? I was confused. At the start of deliberation, AJ tried to get Judge Bev to adjust the verdict form. She kept saying, I believe it is all legal. Can you help explain what that means? Thanks. Yeah. So in the earlier trial, the jury got hung up on this very problem. So when you get a verdict form, the verdict form says, it's almost like a tax return. It says, if you find the defendant not guilty, check here and stop. If you find the defendant guilty, now we have to figure out whether it is the main charge, under what theory, and if it's the lesser included offense. So the next part of the jury verdict should say, if you find the defendant guilty, are they guilty of the highest charge? If not, if so, check the box and stop. If you are finding them guilty of a lesser included charge, go on to the next charge. If you're finding them guilty of that charge, check the box and stop. So that's what Alan Jackson was trying to get Judge Bev to do, was include that so that it was clear, because what the jury asked was, if we convict her of this lesser included misdemeanor DUI, or OUI as they call it, does that mean that we're finding her guilty on manslaughter, on killing John O'Keefe? They wanted that to be very clear, that they could say, yeah, she was driving while she was drunk, but she is absolutely not guilty of killing John O'Keefe. And the verdict form that the judge approved didn't get that specific. And Alan Jackson was correct, because everyone knew that the jury had gotten hung up in trial number 1 on just that issue. That was the issue that hung the jury. The unfortunate part about it was that the judge said to the jury in round 1, do not mark any of the verdict forms until you have reached a verdict on all the counts. Well, that was improper. And this time she specifically said, when you reach a verdict on count 1, mark that verdict form and sign it. When you reach and so it was more likely that if they were hung on count 2, that she would get a not guilty on 1 and 3. So Alan Jackson was trying really hard to get the judge to map that out so that it was so clear that the jury couldn't get hung up on it. And the judge said, I think this is good enough. So my observation is that Judge Canoni didn't like Alan Jackson. She didn't like this highfalutin LA lawyer coming into her town to begin with. She didn't like that he pushed back a lot more than local attorneys usually do. And all along in the trial, there was this element of a power struggle between the judge and Alan Jackson. Primarily Alan Jackson, the whole team, but primarily Alan Jackson. So there was that push and shove, and that little bit of like, there was a control fight going on. And so every time Alan Jackson would push back, she would find a way to say, I'm in charge. So I think that's what happened with this jury verdict form, is that, there were times when Jackson would make an objection, or Jackson would make a legal point, and he was right, and there wasn't anything she could do but say, you're right. And that she didn't like that. But there were also points where she could say, I'm in charge and that's my decision. And the verdict form was one of them. So I think there was a bit of a power struggle going on. And I think ultimately Alan Jackson proved to be right, because they did end up with just the hiccup he was trying to avoid by initially saying, let's use this other verdict form that we've drafted and that we would like to use. And Canoni was just her way of saying, no, you're not in charge, I am. And it backfired on her because it proved that she was wrong, that the jury came back and was confused. So, yeah, Judge Canoni has an interesting personality, and she doesn't like to be told she's wrong. I have observations about judges, particularly women judges in my age group and a little bit younger. So when I was growing up, and a lot of women who are in my sort of generation, we didn't have the kinds of opportunities to learn leadership, executive functioning and leadership. If we were in the Girl Scouts, we learned to bake and to sew. We didn't learn government and merit badges and how to lead other Boy Scouts and Girl Scouts. And if we didn't get it somewhere, we didn't get it in high school and college sports. The sports, if we had sports at all, they were intramural sports or they were girly sports. We didn't have that same level of sportsmanship, of leadership. And so a lot of women didn't get that in their professional lives. It wasn't something that was, they weren't Rotarians and Toastmasters, and they didn't do those sort of organizations that encouraged or taught that sort of management and leadership. They didn't learn management skills. And I was fortunate enough that leadership is something that is required teaching in the military. And so throughout my military career, I took leadership courses. And we see that a lot in men who have been either in corporate settings or in military or in sports, that they get that sort of leadership management sort of training and experience. And a lot of women didn't get that. And I have seen in a lot of women judges in my sort of generation that they're not great leaders. They're not great at managing people. They're not great at I mean, if you look at the contrast between Judge Hippler in the Kohberger case and Judge Canoni in the Reed case, there is a huge, huge difference. The contrast is marked. And Judge Canoni runs her courtroom by being petty and snotty and calling people to task and doing all the things that you learn if you learn leadership are not good skills. So that's my theory of why we have judges like Judge Gull and Judge Canoni, who are the because I said so kind of leaders, because they never learned how to do it the right way. I mean, I encourage young women at any point, if you are offered leadership training, take it. Read all the books. Read the books all the CEOs read, and understand what it means to be a leader. Whether you are in a company, whether you are in a law firm, whether you are in government service, you absolutely have to understand leadership and show those leadership qualities. And I think that's where the women in my generation fall down, the Judge Canonis and the Judge Gulls of the world. They think that leadership is because I'm in charge and I said so. And it doesn't always result in the best outcomes. So what else we got? Hi, Rachel. Part 1. Both Judges Gull and Canoni have been accused by many true crime followers as biased. I'm not disagreeing, but I can't help but notice both were presiding over controversial cases. Yeah, I don't disagree either. Oh, part two. Do you think that all judges lean toward the prosecution side of things, and these two just stood out because so many people felt the defendants were innocent? Rachel, this is a great question. Two things. Yes, I do believe that judges tend to, I won't say judges, I will say the law tends to favor the prosecution. So when you are in a trial, because the prosecution has the burden of proof, they get a lot of leeway. Okay. So, for example, when you are trying a case and the prosecution puts their case on and the defense goes to the judge and says, Judge, I want a dismissal or a finding that the state didn't prove their case. Well, the standard is taking all of the evidence in the light most favorable to the prosecution. Did they prove their case? So those are the sorts of things that are built into our system that favor the prosecution, because they do have the burden of proof. So yes, I think that that they were prosecution favorable, but I do think that in both cases, both of those judges had in Delphi as with Judge Gull, as well as Reed and Judge Cannoni. I think both of them had a real dislike of the defense. And I think that both of them had a real sense that in some way the defense was challenging their authority and their power. So one of the things I think that women leaders don't always understand, or don't always, how do I put it? They don't always understand, I guess is fine, that the challenge isn't to them personally. The challenge is to the facts and the law and that it is not an issue of when I object and I want you to hold the prosecution to their obligations, to the rules of evidence. It's not personal. I'm not attacking you personally. I'm saying you are the person who's responsible to call the balls and strikes. I can say I disagree with the way that you called the balls and strikes, without it being personal. Okay. And that is not something that either Judge Gull or Judge Cannoni did very well. They were not able to separate out the personal. So when Alan Jackson says to Judge Cannoni, I don't agree with your ruling, he is, because he understands his role, he is saying, I'm making my record that I don't agree with your ruling. Judge Cannoni is saying, oh, that's a personal affront. I'm taking that personally. And I think that both of those judges did that to some degree. Certainly, Judge Gull did not like the Delphi defense. She tried to get him thrown off the case. And they had to go all the way to the Supreme Court to get put back on the case. So no question that I think in both cases, in both instances, the judges, and I don't know why that is. I don't know if that is sort of a function of not being great leaders or not being great trial attorneys. I don't know, because you can't be a trial attorney and take everything personally. You just can't. you go down in flames. You know, you lose your mind quickly if that's the case. You just cannot approach trying cases that way. So to approach sitting on the bench that way is suspect, is questionable. You cannot approach presiding over high visibility case like that and take every objection as a personal affront. And I certainly think that Judge Cannoni in particular felt that she was in a power struggle with the defense. And that should never be the case. Never be the case. And you should be able to say to Alan Jackson, your objection is noted. I have noted for the record that you disagree with my ruling, period. But it doesn't have to become a pissing contest. So, and I think that in a lot of ways, Judge Cannoni made it that way. And that's not great judicial temperament, which is why I'm not a judge, because I never had the temperament for it. Too often, I think I would have spoken my mind. Hi, Mary. Can Karen Reed go after the state? If you're asking, can she sue the state for wrongful prosecution? I believe she can. I think there's always a question when someone is convicted of any count in a case, as she was convicted of the DUI, whether or not that negates, you know, whether the state can come back and say, well, it wasn't a wrongful prosecution because she was convicted of this count. In this case, I think because the DUI is so completely unrelated to John O'Keefe's death, I think that actually she can sue the state. I see this comment from Leah, and I'm going to put it up because I did know that that this happened. Andy Baldwin recently got a not guilty on a murder case in Judge Gull's courtroom. He was defending a woman who allegedly killed her husband, and there's supposed to be a dateline coming up on it. Yeah, I did see that. And I think there has already been a brief clip on maybe 2020. I can't remember, but I think there is a whole Dateline episode coming up. And yes, he did get a not guilty verdict on that case in front of Judge Gull, which must have really chapped her hide. Yeah. What other questions do we have? Is there any reason Karen Reed cannot write her memoir? Absolutely no reason, and I hope she does. I hope she's been keeping journals, and I hope she does. No. So in the case where someone is convicted, like Lori Vallow, most states have what's called a son of Sam law or some similar permutation, which says that a convicted defendant cannot profit from their crime. So because she wasn't convicted, she is free to write, and I hope she does. I hope there's a big publisher there just waiting in the wings. And I'm certain that she's getting good advice from her legal team about how to go forward. Hi, Teresa M. When is the Grandma Gone Wild trial? Also great to see you. I missed all of you as well. And I want you all to know that I'm super excited about this new project, and I appreciate your patience while we wait for it. But I don't want to go public until I'm sure that everything's in place. So the Grandma Gone Wild trial, if you're talking about Adelson, she's still trying to get her case bumped out, and I haven't seen anything recently about whether or not she's going to get that continuance. They got a bunch of new discovery, and then there was this whole thing about whether or not the the defense attorneys were allowing her to talk to Harvey on their cell phones, and I haven't really seen the progress that's been made on that yet. So if that's the one you're talking about, that one I think is still on for July. I'd have to pull out my list. But I kind of think that's written in pudding right now. So I wouldn't be surprised to see that one get bumped out again. And the grandmothers, the Oklahoma, Kansas grandmothers, I haven't heard anything new about when that one might go to trial. Tiffany Adams. So, but we have some bad acting grandmas out there. So, which is also sort of on the back burner as maybe something I might want to write about. Grandmas who are bad actors. And yeah, the Oklahoma grandma. Yeah, I haven't heard about her recently, but I'll look that up and I'll get everybody caught up for next week. Yeah. Thanks, Beth. Rachel Gamber has been following that case pretty closely, and she keeps me up to date on when things change. And I haven't heard much lately. So I think that there's sort of, they did, oh my goodness. I just see a post from Julie that says Michael Proctor did 20/20 tonight. Man, oh man, I'm going to have to catch that. That's going to be interesting. And I think I'm sure he's going to be civilly sued, and I would be very surprised if there aren't some criminal charges coming for him for misuse of his police power. So let me know. Please, once again, like and subscribe if you haven't. Let me know if there are cases that you are interested in or would like for me to look into. I will definitely update trial dates for next week. And thanks so much for your support and your patience. Go ahead. What do we got, Jen? And you also have the Utah grandma who Googled Adelson. Right. Yeah. There's some bad acting grandmas out there. So, yeah. And Utah, really. Yes, please go subscribe to Microdots. They are amazing. And they have done some really fun stuff. There's also a Karen Reed AI. I'll drop that in. And that's the one where they turned everybody into little babies and little children. And it's adorable, really cute. Including some of your favorite law tubers got turned into babies as well. So, and along with Karen and Alan Jackson and Brennan and Judge Cannoni, they all got AI'd into babies. So it's really cute. I'll drop that link as well. So please. Thank you. Well, thank you so much. I love being with you guys, and I appreciate your attendance and how faithful this group is. You're here every Wednesday night, and I appreciate it. And I still think we have the best community ever. So thanks again. Thank you, Jennifer, for always being the best moderator in the world. And I'm going to say good night. Have a great week. We'll get back together next Wednesday. And until then, I'm going to say good night.